Hello and welcome to the discourse on right against arbitrary arrest. To start with, when a person is arrested contrary to the provisions of law that are enacted under the Criminal Procedure Code or under any other law providing for arrests, then such arrests and detention will amount to arbitrary arrests. The Constitution of India enacted under Article 21 that no person shall be deprived of his life and personal liberty except according to the procedure established by law. Arresting a person is certainly to result into deprivation of the arrestee of his personal liberty, and as such, all arrests must be effected according to the procedure of arrest that one established by law and not otherwise. Section 60A of the Code of Criminal Procedure 1973 provides that no arrests shall be made except in accordance with the provisions of this code or any other law for the time being in force providing for arrest. The Universal Declaration of Human Rights 1948 has declared under Article 8 that everyone has the right to an effective remedy by the competent national tribunals for acts violating fundamental rights granted to him by the Constitution or by law. The Constitution of India has declared under Article 32 that right to move the Supreme Court for the enforcement of fundamental right is guaranteed. Therefore, since arbitrary arrest is deprivation of right to life without the procedure established by law, one may move the Supreme Court in appropriate proceedings for the enforcement of fundamental right. The Code of Criminal Procedure 1973 has also enacted in its several provisions relating to the claim of compensation for wrongful accusation, the liability of the wrongdoer. Under the law of torts of malicious prosecution is another aspect relating to remedy in case of arbitrary arrests. The constitutional remedy and the criminal prosecution in case of arbitrary arrests shall be dealt with separately. The present discussion shall center around the provision enacted under the Code of Criminal Procedure regarding claim and grant of compensation for arbitrary arrests and detention. Incidentally, it is also relevant to refer to the concept of malicious prosecution under the law of torts. Section 358 of the Code of Criminal Procedure 1973 lays down the provisions for compensation to the persons groundlessly arrested. Under Section 358, whenever any person causes a police officer to arrest another person, if it appears to the magistrate by whom the case is heard that there was no sufficient ground of causing such arrest, the magistrate may award such compensation not exceeding 1,000 rupees to be paid by the person so causing the arrest to the person so arrested for his loss of time and expenses in the matter as the magistrate thinks fit. All compensation awarded under this section may be recovered as if it was a fine and it cannot be recovered. The person by whom it is payable shall be sentenced to simple imprisonment for such term not exceeding 30 days as the magistrate directs, unless such sum is sooner paid. This provision enacted under section 358 of Code of Criminal Procedure is applicable in the cases where a person causes another person to arrest by a police officer where there was no ground or sufficient ground of causing such arrest, and when such case comes before a magistrate where the magistrate found that there was no sufficient ground for arrests. This is enacted under section 250 of the Code of Criminal Procedure, 1973. Compensation can be granted to the accused by the Court of Magistrates when accusation was found to be without reasonable cause. The distinction between section 358 and the present section 250 is that in case of section 358, when the magistrate first detected that a person was made to arrest by another without sufficient ground. Under section 250, the accusation before the court was found to be without reasonable cause after the case being proceeded for a longer period, and where such accused is discharged or acquitted, the magistrate shall record and consider any cause which such complainant or informant may show. If the magistrate is satisfied that there was no reasonable ground for making the accusation, make an order that compensation to such amount, not exceeding the amount of fine he is empowered to impose, as he may determine, be paid by such complainant or informant to the accused or to each or any of them. The magistrate may, by the order directing the payment of compensation, further order that in default of payment, the person ordered to pay such compensation shall undergo simple imprisonment for a period not exceeding 30 days. This compensation payable under this section is not the full and final settlement of compensation in the matter arising out of accusation without reasonable cause. The section further provided that no person who has been directed to pay compensation by reason of such order be exempted from any civil or criminal liability in respect of the complaint made or information given by him. Section 220 of the Code provides for punishments to an officer or authority who detains or keeps a person in confinement with a corrupt or malicious motive. The ingredients of the section are: whoever being in any office which gives him legal authority to commit persons for trial or to commitment or to keep persons in confinement corruptly or maliciously commits any person for trial or to confinement, or keeps any person in confinement in exercise of that authority, knowing that in doing so he is acting contrary to the law, shall be punished with imprisonment of either description for a term which may extend to 7 years, or with fine, or with both. Sections 330 and 31 of the Penal Code provide for punishment of those who inflict injury or grievous hurt on a person to extort confession or information in regard to commission of an offence. The illustrations A and B of section 330 make a police officer guilty of torturing a person in order to confess the commission of a crime, or to induce him to point out places where stolen property is deposited. Therefore, making a person an accused and induce him to make confession by using coercive measures by the police is an offence, and such arrest is an arbitrary arrest, and a police officer will be guilty under these sections of law. These penal provisions are the laws against the police and arresting authorities against arbitrary arrests. The case of wrongful arrest and detentions are bound to happen, as when powers are given, then there will be cases of abuse of such power. Various remedies become relevant in the matter of arbitrary arrests and detention in criminal law, and also on the law of civil nature. There is also the tortious liability, and a reference to the concept of malicious prosecution will not be out of place in the present study. Malicious prosecution consists in instituting unsuccessful criminal proceedings maliciously and without reasonable and probable cause. When such prosecution causes actual damage to the party prosecuted, it is a tort for which he can bring an action. The law authorizes persons to bring criminals to justice by instituting proceedings against them. But if this authority is issued by somebody by wrongfully setting the law in motion for improper purposes, the law discourages the same. To prevent false accusations against innocent persons, an action for malicious prosecution is permitted. In an action for malicious prosecution, the applicant, that is the accused, has to prove first that he was innocent, and his innocence was pronounced by the judge before whom the accusation was made. Secondly, that there was want of reasonable and probable cause for the prosecution, that in the eyes of the judge, inconsistent with the existence of reasonable and probable cause. Lastly, the proceedings of which the complaint was initiated are in a malicious spirit and not in furtherance of justice. In a suit for damages for a malicious prosecution, the plaintiff is to prove the following essentials. Number one, that he was prosecuted by the defendant. Secondly, the prosecution was initiated without any reasonable or probable cause. Thirdly, the defendant acted maliciously and not with a mere intention to carry the law into effect. Fourthly, the proceedings complaint is terminated in favor of the plaintiff. And lastly, the plaintiff suffered damage as a result of the prosecution. The corresponding provision of malicious prosecution under the criminal law is enacted in section 250 of the Code of Criminal Procedure, is not an alternative of the law of malicious prosecution. An accused person who is wrongfully implicated may pursue both the provisions. In this regard, section 250 subsection 5 of the code explained that no person who has been directed to pay compensation under section 250 shall, by reason of such order, be exempted from any civil liability or criminal liability in respect or the complaint made or information given by him, provided that amount paid to the accused person shall be taken into account in awarding compensation to such person in any subsequent civil suit relating to the same matter, even though the law of malicious prosecution is a corresponding law to section 250 of the Code of Criminal Procedure. The remedy under section 250 is easier for an accused person to avail of as a remedy of the false accusation. The magistrate, while discharging or acquittal of the accused, by the same order grant compensation when he finds that there was no reasonable ground for making the accusation. The procedure is simple and easy, that the magistrate require the person who initiated the proceedings against the accused person to show cause as to why he should not be ordered to pay compensation. The magistrate shall consider the cause shown by the complainant or the informant, and by recording reasons in writing, make an order for compensating the accused person not exceeding the amount of the fine that a magistrate may award under the code. But in the case of malicious prosecution, the procedure to avail of the benefit is too technical, and the accused, as the plaintiff in such suit, has to discharge the burden of proof in a very heavy terms, and that is the reason that malicious prosecution is not very popular as a remedy to be availed of by an accused person in the case of unsuccessful criminal proceedings against him. Apart from the provision for granting bail of a person who has been groundlessly or arbitrarily arrested, there is another very useful remedy under the Code of Criminal Procedure 1973. The said remedy is enacted under section 97 of the Code. The provision is search of person and thereby arrested or detained arbitrarily. The remedy under section 97 is very useful. The provision goes as if any district magistrate, a subdivisional magistrate or magistrate of the first class has reason to believe that any person is confined under such circumstances that the confinement amounts to an offense, he may issue a search warrant, and the person to whom such warrant is directed may search for the person so confined, and such search shall be made in accordance therewith, and the person, if found, shall be immediately taken before a magistrate, who shall make such order as in the circumstances of the case seems proper. This is a provision to remedy an arbitrary arrest and detention. This provision is easier to avail of than a remedy of habeas corpus before a high court, for the reason that the authorities like the magistrate are closer to the people and easier to make approach than a high court, which is expensive, highly technical. Further, in the case of habeas corpus, the high court can direct the opposite party to produce the body of the person wrongfully confined, but a search warrant can make a search as well as to liberate a person wrongfully detained, as the person cannot make the application in person. The rule of locus standi, which requires the affected persons to espouse their own cause, is relaxed in the case of arrested persons. In making application for bail, search or habeas corpus, as the case may be. Friends, we can conclude by mentioning that the right against arbitrary arrests and detention is long cherished right of the people. Numerous provisions have been made in the national, international and domestic laws. There are provisions of grant of compensation to the persons groundlessly arrested, and compensation for accusation without a reasonable cause as criminal law remedies that could be granted by the courts of magistrates. There are also civil remedy for damages in case of abuse of legal procedure actionable under the law of torts. Apart from the writ of habeas corpus that can be issued by a high court, the provision of issuing search warrants by the executive magistrates under the Code of Criminal Procedure will afford cheap and speedy remedy in case of an arrest if such detention amounts to be an offence. Thank you very much.